Welcome back, and thank you very much for choosing to stay with us as we look at the analysis of what has been happening or transpired this particular week. But we follow it back to when it started, the motion in the National Assembly, a bit of uncertainty between the working relationship that is between the Deputy President, now former Rigathi Gachagua, and the sitting President William Ruto, all the way to today, where we have seen the National Assembly vote in favor of now replacing Rigathi Gachagua with the Professor Abraham Kithure Kindiki, who is serving as the CS of Interior, where he has also been in legislation or has served as a legislator for 10 years. They are bringing in a number of reasons why he qualifies as the now Deputy President, including his professionalism, his working relationship with members of Parliament, his working relationship with the President. He's having, quote unquote, if you use that language, the back of the President, regardless of the time in 2022 when information has it that majority of the Kenya Kwanza brigade had vouched for him or rooted for Kindiki to be the Deputy President in that election in the first place. Nevertheless, he still then worked with President Ruto in his administration. But let's come back now to what is happening in the country. What are we looking at moving forward? Mashujaa Day is just around the corner. We had different voices. In fact, John Swaka and of course Willie Sotieno will be joining us again virtually. John, we had voices prior to the Senate even acting on Wednesday, Thursday, yesterday and today, that there was word that it is important, and it was already a prospect, that we have a Deputy President by end of week and fresh by Mashujaa Day. Seemingly this is coming to pass before we even go back again to this stay order that is now bringing in a bit of confusion for Kenyans that need to understand it better. But let's take a look at the political process. It is like it was already foreseen that by end of today, by this weekend, we have a Deputy President.
Yes, of course. With the way things have actually moved, with the speed and with the focus of both the National Assembly, the Senate, and of course the happenings today at the National Assembly, you can only confirm that there is an urgency to have this particular position filled up. And just referring to the order that I've seen, if it is the order that you've been referring to.
Yes.
Sorry. This order, first and foremost,
Kenyans will be asking, is the court stopping Gachagua's impeachment? Is the court staying the National Assembly from voting? What is the court order?
When I look at the ambit number 3, it basically says that a conservative order is hereby issued staying the implementation of the resolution of the Senate upholding the impeachment charges. But you have to understand that the implementation of the resolution by the Senate has already passed. Because after the Senate did actually impeach the former DP, the same was gazetted. And so the process already moved. And from there, the president did actually give a name of a nominee. And see, this order is saying that it sought to stop that particular gazette made. It sought to stop the issuing of a nominee, the name of a nominee, and it's also sought to stop perhaps the National Assembly from approving the new nominee. But all this has been overtaken.
All right.
So the orders come late in the day when all these processes have taken place.
So therefore you're saying there must be a timing and a timeline in which this court orders come in?
Yes.
Prior to whatever the process is that is implemented is done.
Yes,
so
because had the court order come out, let me say, a little bit earlier,
yes,
then the president would not have, actually the gazette would not have taken place, the president would not have forwarded a name of a nominee, and Parliament would not have had the opportunity to approve the new nominee. And so all these things have passed. And so what remains is just for the deputy president designate to be sworn into office.
As a lawyer then, do you then say or conclude that Rigathi Gachagwa's legal team failed him?
I will not say that, but I just say that at times with the challenges of time and when these things happen, because you see, this resolution was passed almost 11 in the night, going to midnight. It was gazetted. And you see, maybe by the time they put the paperwork together and go before a judge, for the judge to look at the file and give back directions, time has moved and a lot of processes have taken place.
We had a voice speak yesterday morning, early morning, Wakili, 7 a.m. thereabout, saying Gachagwa's team should be working around the clock to work on things like this. That was said yesterday at 7 a.m. on the second day of the impeachment trial before the Senate. And that is why I'm interrogating the questions and concerns arising around the competence of course, with all due respect,
perhaps the papers
of that Paul Muite-led
the papers may have been ready, but at times, you see, you're not the one to make the decision because you take the papers to court. It's the court to make a determination. And you can't act on your papers. You can only act on what the court now gives as a feedback to what you have filed.
Now, for a layman's understanding, because we cannot assume, you guys call yourselves learned friends, as we also wait for Wakili Willis Otieno to join us. In a layman's language, because this is a deputy president for all Kenyans. I mean, talking to someone in Samburu, Turkana, Bungoma, Migori, all right? And they want to understand the legal terms here, all right? What is the interpretation, in a layman's language, of this particular order? Well, not just what it has said, but what is the interpretation of the order in a nutshell?
In a nutshell, basically, the order sought to stop any further process from the time of the impeachment. So when the resolution to impeach the former deputy president happened, it was now meant to stop that position going forward. But you see...
Let's walk this journey. From the time of impeachment, we can also go back and say, because I'm doing this for the sake of the common man, the National Assembly at the time, which of course they said was not very important, I mean it wouldn't have such effect, voted 282 in favor of the impeachment, right? Now this moved to the Senate. We had day one of the cross-examinations, witnesses, that is on Wednesday. They read out the charges, etc. And then we came into Thursday, where then we saw the chief witness not available due to health issues, his lawyer said, to the attempt to at least give some time, but then it proceeded anyway, you said followed to 11 p.m. Pursuant to the Article 145, the Speaker then shall declare that the former Deputy President is impeached. At what level of impeachment are you talking about that this particular court order stayed so that the Kenyan understands? Because according to Kenyans, alikuwa impeached.
Oh, very well.
Yeah, so that they understand.
That is when you look at the order, it says a conservative order is hereby issued staying implementation of the resolution by the Senate.
The Senate.
At the Senate level.
Okay.
So that is what was meant to have been stayed. So that means if that is stayed, then there is no gazettement. Number three, then there is no, the president will not be able to forward any name of a nominee. And subsequently, Parliament, the National Assembly will not be able to sit and vote for an approval of that particular nominee. And you see, all that has happened already. So that is where the quagmire is. That is where the quagmire is.
I'm still waiting to hear if Wakili will join us. Willis Otieno was with us virtually. But I want to read a bit of this, but of course we are also joined by Duncan Ojwang at this very minute, and it's very good to have you this afternoon as we are also discussing then what is happening in the country. Standing Order 73 of the National Assembly allowed the members of Parliament to vote. We saw action in Senate as well. To this point, Ojwang, we have seen a name forwarded to the National Assembly, and we have seen now a new Deputy President-elect, Professor Kithure Kindiki. However, A stay order has surfaced and is now in public domain. And perhaps if you could also give us an interpretation of this order stay, or stay order, if you like, for the sake of clarity. Has it been overtaken by events at this point, Ojwang?
I think so, because right now all the court can do is to quash and not to order, because the order is talking of appointment of his replacement, which has already happened. It's simply saying that there should not be appointment of his replacement. That has already happened in the morning. Hello?
Yes, we can hear you, Daktari.
Yes, and it does. So the order is invalid to that extent that it has been overtaken by events. There is already appointment that has been done and taken to National Assembly. So, of course, that will be the argument probably on this side that there is no way I could have complied with that order because this action has already taken place. What the court could have done is to quash that replacement. Or to quash the process that has gone before, but not to stop it because it has already happened.
What would be the difference? To quash?
The difference is to quash is to say that that action is invalid or it has no legal effect. But to stay is to say, don't do it, yet you have done it. And therefore, what you are staying is already done already. So there is nothing to stay to that sense.
All right, what you're saying then, Dr. Ojwang, is that at this point in time, Professor Kithure Kindiki, as the new deputy president-elect, is not, forbidden from taking the oath of office. Just for clarity, and as far as this order is concerned, he is free, all right, and legally allowed to then take an oath of office as a new deputy president-elect. Is that clear?
I think so, yes, because he was appointed before the order, and the order is staying his appointment, which has already happened. So if you look at even Article 74, there is no requirement that it is the Chief Justice who must do the swearing in. It's just a tradition that has been done. It just requires that the oath is taken in a manner prescribed by the third schedule under the Act. And so the swearing can be done in whichever way, but the order that is staying his appointment is overtaken because remember he was appointed in the morning.
All right, he was appointed in the morning, but we had the voting, concluded in the afternoon. Are you saying then that despite the appointment and the name for it to the parliament, something could have happened in between, is it the appointment or is it the voting and approval by the parliament, that is the National Assembly, that is heavier, or both?
You see, when an order is given, it must be specific and not open or vague. So that when you say you have quashed his appointment, if you look at the Constitution in the series of events following the impeachment, is that the appointment is done by the president. In fact, the exact word, I believe, under Article 147 is that within 14 days, the president shall appoint the replacement and or a nominee. And therefore, when you are saying that you have stayed the appointment, you have then simply tried to stop the president in an action he has overtaken. Now, the order does not say his replacement. Now, if it could have said you have stayed his replacement, then now that can be broader. But you have simply stayed the appointment, which is an action that already took place in the morning.
Is there any window, Daktari, for a rebuttal by Gachagwa's legal team at this point in time as things are moving? Do they have any other window whatsoever to challenge what's happening?
Yes, somebody should go to court to ask for clarification of this order. Somebody should, of course, they should serve the order as it is, hoping that maybe those who are undertaking the exercise will give a broad definition. But you know that it is more of good luck. But they can go back and seek clarification or amendment of the order. But it has tried to injunct an activity that is already done. The word appointment, they should have said replacement.
Interesting, but before we even go back to Wakili Willis Otieno joining us virtually as well, still Dr. Duncan Ojwang, I may need to seek your thoughts on this matter in as far as the timeline vis-a-vis the process that the impeachment happened is concerned. There are arguments that the deputy president ought to have been given time to respond. Other legal voices arguing that we didn't have such time. This position needed to be filled as soon as possible, and there is no provision for extension whatsoever in as far as the Senate's behavior was concerned. What is your legal argument, Daktari, in as far as the timeline in which the Senate, did the investigations, if they ought to have done investigations, and even to the point where the Senate Speaker Mombasa Road declared the impeachment official?
I think that there's a strong argument that things were rushed, but there's no legal requirement that you must slow down things. Number two, remember this is a prescribed and a timed activity because the Constitution came knowing the bad manners of Kenyans that sometimes they drag their feet or in what they should do. But if it comes to the issue of he should have been heard, and of course, that will be an issue that will be big in court against the natural right of, the right to be heard. Whether having a battery of a senior counsel will have surfaced to do that, whether the fact that he already appeared in the first day and, said, rejected all the charges and was part of it and things were fine. So there is a way that court can look at the totality of events in order to see whether there is a right due to you. And that right was not done. But overall, there is this impact that Kenyans have that they look at this appointment almost like a right to property. I don't think you have a right to be a deputy president. It is a position out of trust, and therefore, it is not like you are going to jail. Why am I saying that? Based on what right you are losing, the procedure becomes bigger, what is due become more serious. For example, you are losing your right to liberty or you are losing your property. Now, to what extent are you owed a lot of due procedure when it comes to a public office for a function that is already given to another arm of government as parliament?
If you may stay with us on phone. Allow me, John and Daktari Ojwang, to listen to the thoughts of Wakili Willis Otieno, who is still with us. Wakili, when we took a short breather, there was need then to also engage you in perhaps interpreting this order again, because John here tells us, and of course you've heard Dr. Ojwang saying, if only the courts used the word quash, it would make a difference. And according to Dr. Ojwang, the now deputy president elect is free. He's legally, allowed to take oath of office. This is different from what we heard you say earlier on after this order, came to our attention. Perhaps you have a different interpretation. Do you agree with Dr. Ojwang?
That court order is so clear. It doesn't need interpretation. it stops the implementation of the resolution of the Senate and anything done in consequence of that order. So everything stops from the time when the Senate passed a vote. Even the sitting of the National Assembly, the submission of the name of Kithure Kindiki, the gazettement of the impeachment motion, the nomination of Kithure Kindiki, they have all stopped because those are consequences that arose from the resolution of the Senate. That resolution of the Senate has been stopped, and any consequential action that was done in furtherance of that resolution. If Dr. is talking about if they call it the word quashed, no, quashing will come later. This is about preserving the status quo ante as we deal with the petition. The issue of quashing is a final order that can only be made upon hearing all the parties, including Kithure Kindiki, if he so desires to participate as an interested party in those proceedings, and the court makes a determination after considering every representation by all the parties, then it will quash. But at this stage, you don't require the court to quash because this is an ex parte order that is meant to preserve the substratum of the petition that is before the court. So as it is right now, Kithure Kindiki can hold his horses, let him wait to the 24th, when the court will give further direction of the hearing of the application and the petition. If the court maintains those orders, you still have to wait for another opportunity. And if the court hears the case and determines that the Senate was wrong, then they'll have to go back to the political drawing board to find a new avenue through which he can become a deputy president. As it is now, that resolution impeaching Rigathi Gachagua has been stayed. It is stopped. And that is why I said Rigathi Gachagua at this point remains the deputy president, whether anybody likes his face, doesn't like his face, doesn't like his conduct, but he remains until we get to that stage that the petition is determined, and depending on the outcome, we'll know where the matter should proceed. So anybody who is saying that we'll ignore the court order, then we say we can as well do away with our constitution. We now become a country of the rule of the jungle and not the rule of law. We stop pretending that you are gazetting Kithure Kindiki, you stop pretending that you are swearing him in to uphold the constitution. That constitution has told him wait, and the court as the ultimate arbiter has said we are staying that resolution.
All right. I want to talk about the timelines in which this stay order comes in. Wakili, before I hear from John here in studio, because I know he needs to respond to both you and Dr. Juang. Timelines. The order might be what you are saying, but at what point is it effective is the concern at this point, Wakili. If it did come after the appointment of Kithure Kindiki, and that is the question.
You know, the court order starts taking effect from the time the resolution which is impugned was passed. So anything that is done in furtherance of an action that has been stopped by the court by itself also is stayed. It becomes unconstitutional itself if you proceed with it. Because now the court has taken us back to exactly where we were before the resolution was passed. So as it is, nobody can argue that, oh, Kithure has been nominated, Kithure has been voted for by Parliament. No. Those are consequences of the resolution of the Senate.
All right.
Anything done as a consequence of that resolution is stayed at whatever stage they have reached. Even if Kithure Kindiki had assumed office and the resolution which had been passed to make him a deputy president is stayed, even his sitting in office being a consequence of the resolution of the Senate becomes stayed. That is a plain reading of the law, and that is basic interpretation, not just of court orders, but of basic English, that all Kenyans, in their own wisdom, should be able to read that order and interpret.
Now, Wakili Willis Otieno saying basic English, but what I'm getting here, even as you're watching back at home, is I am engaging legal voices. I have in studio a lawyer, John Swaka. I have also on phone Dr. Duncan Ojwang, who is also an advocate of the High Court, but they have seemingly different interpretations of the same stay order. John, you wanted to respond to what Willis has said in as far as his interpretation, which he says you need to basically interpret as he is in basic English.
Basically, an order will take effect upon its service.
Upon its service.
How will you know there's an order saying ABCD? It's when the order is made when you have a revelation of the order. Because it's assumed that you do not know until the time you are ordered, until the time you have the document saying do X or B or Y. Now, when you look at this order, limb number 3, it's basically saying that this order is staying the implementation of the resolution of the Senate. But you see...
And what is the resolution of the Senate? The
resolution of the Senate was that the former Deputy President stands impeached.
All right.
So from there, the other processes. So these processes have already taken place because that said position was gazetted. The President did give a name of a nominee, and the National Assembly, pursuant to Article 149 of the Constitution, has already gathered, sat, and actually approved. So the process that was meant to be stayed had already moved on, to the extent that as we speak, there is a Deputy President designate who, as Dr. Juang rightly put, does not even need to be sworn in by the judiciary or by the Chief Justice.
Okay.
Can just be sworn in by an advocate who can lead him through an oath of office, and that will be it. And so as it is right now, this particular intention, what this particular order perhaps intended to achieve, has been overtaken by events.
Has been overtaken by
events. To the best of my interpretation.
Let me go back to Dr. Duncan Ojwang. Dr. If you were listening in, you heard what Wakili Willis Otieno said. He seems not to be in the same line with your interpretation. I don't know what you have to say in as far as that is concerned. It's a totally different interpretation, Wakili. He's saying this means that even Kithure Kindiki should not assume or take over this office. He's saying the stay order is effective regardless to this point in time. I just need perhaps if you listened in, to perhaps also bring in your interpretation on the same, or a clarity to him on the same.
I don't know whether Wakili Louis is talking of order they should have got or the order they got. Because adding words like in subsequent action, that is not in the order. I accept it on social media, and therefore we might be doing different orders, but there's nothing like in all subsequent action. It needs very good drafting. Maybe that language will have saved the day. But that is not in the four corners of this order. It simply talks about conservative order is hereby issued saying implementation of the resolution by the Senate, upholding the impeachment charges against the petitioner, the Deputy President of Kenya, including appointment of its replacement until 24th October. So they want, and the consequential is not there. And that is why, for me, what is said is appointment of its replacement. Let's read the order with what it has, not what we wish it had. State appointment of his replacement. That has already happened. His replacement has already been appointed, and therefore, the order does not stop assumption of office. What was hard for court to just say that? It is on impeachment. The order is therefore overtaken by event because it's stopping actions that have already happened. The order stayed appointment of his replacement, which has already happened. We know by now that the replacement is Kindiki by name. We know it was voted. Now, if the court wanted to simply injunct assumption of office, what could have been harder than to say so? And whether that is drafting, whether that is techniques, whether that is technicality, but for now, the order clearly talks about appointment of his replacement. That has happened. Now, maybe there could be an argument that that appointment is not complete until the swearing in. Maybe. But to say that, so the word consequential actions is not there. It is simply appointment. He has already been appointed. The code and the order are not meant to be vague or to be subject to whoever. So if, for example, let's take the worst case scenario and the minimalist argument that if suppose Wakili Lewis is right, the other side will also not be found to have violated the order because they will make a good argument that in good faith, this tell me why this could not be a good interpretation of your order. That you injuncted appointment of his replacement, which had happened. So yes, there could be other interpretation. There could be an assumption that we can assume we knew what they were trying to do to stop, but I don't think anyone can say it is a bad faith argument to say that somebody read the orders to say what was stopped or injuncted was appointment of the replacement, which had already happened. Now, that is why I was saying at that point, court could have simply talked of quashing that appointment.
And that is what Wakili...
knew it had already been appointed.
Yeah. I'm sorry to interject. I'm still with you, Wakili Dr. Ojwang, that, and I'll go back to Willis Otieno again shortly, but that is what I asked as well, and Willis Otieno was clear that the quashing would come way later, and that terminology would not make a difference on this particular stay order at this stage. He says the terminologies you're bringing up, the quashing, yes, is valid, but comes way later towards a given period of time, not now. It wouldn't really affect or put a different effect to this stay order, contrary to what you said, Dr. Ojwang. Dr. Ojwang, but we will be able to get back. Doctor, of course, Wakili Willis Otieno, maybe you're still there with us. Before I come back here to John, who's also a lawyer, I know you followed closely what Dr. said. And
let me say this. First, when John says that the court order takes effect when it is served, that is so fallacious an argument. A court order takes effect when it is made, when it is issued by the court, not when it is served. The question of service and being aware of can only come in when you are defending yourself if you are charged for contempt of that order, where you are saying, I was not aware. But now that you are aware it exists, that which you did in between is illegal. You cannot continue with it. It stopped. So that we say the court order takes effect from the time when the judge issues it. The judge has issued an order staying the resolution of the Senate. The judge has stopped an order stopping the appointment over replacement. So once that order stayed the resolution of the Senate, you go to the time when the Senate made the resolution. That order of stay takes effect from the minute when that order is issued. If it is issued at 9, you go to 9 o'clock, and its effect is even retrospective in nature. So the resolution stopped taking effect from the time when the Senate passed it. And on the argument by Dr. Joan that the court order did not touch on the appointment, the appointment is a consequence of a resolution. Where does William Ruto get the legal authority to nominate Kithure Kindiki? In fact, as it is, all he did was to nominate the name. It went to the assembly approved. The formal appointment takes place at the point of taking an oath of office and being sworn in. And John is wrong to insinuate that even an advocate, a commissioner of oaths, can administer the oath to Kithure Kindiki. They can as well go ahead and do it. But I'll say this. The Constitution prescribes that you can only take an oath of president or deputy president before the Chief Justice or the Deputy Chief Justice of the Republic of Kenya. That is limited to who can administer that particular oath. If that was not the case, the oath of office could have been administered by the many advocates and commissioners of oaths that we have across the country, could have done it. So let's just be fair and let's be factual and truthful to all Kenyans. The court is the ultimate arbiter of wrong or right. As it is now, that court has said we've restayed the implementation of the resolution. We've stopped an appointment. Let's all say, okay, we go back to where we were before the resolution. And that is what the rule of law is about. Being fair to everybody, even when you don't like them. So you may not like Rigathi Gachagua today, but at least seek solace in the rule of law. Because that is where all of us derive our protection. If we decide to interpret and apply the law in a way that suits my present political circumstances, then we are creating a state of anarchy. Even if we disagree politically, we argue politically, we pursue political interests, but on the question of interpretation of the court orders or application of the rule of law, we leave it to the courts. Once the courts have spoken, we may not agree with their ruling, we may not agree with their order, we may not agree with their posturing, but at least for good order in the nation, we leave it to the court and we are there to that which the court has said, irregardless of our feelings about those orders or those decisions of the courts. Because the court is doing this in furtherance of the rule of law.
Thank you very much. That is Wakili Willis Otieno, an advocate of the High Court of Kenya, who's joined us this afternoon. We're looking at the interpretation of the court orders, the stay orders, and of course you've heard legally a number of cases may, surface before the courts. This was pretty much foreseen as the Deputy President or former Deputy President Rigathi Gachagua had initially in a number of instances attempted to have this process stopped. First, at the first level in the National Assembly, that was brought in as a motion by and sponsored by the first-term Member of Parliament and lawyer, Member of Parliament Kibwezi West Mutuse. But then also the public participation, he made an attempt there. The court said we shall not inject. It moved closer to stopping the Senate from even beginning the process to start with. All this were not successful for his team. And I just want to hear from you, John, because in as far as swearing in the new Deputy President is concerned, perhaps if you could bring for clarity, Willis Otieno says what you're saying is but misleading Kenyans.
No, you see,
in as far as who swears in the Deputy President, he said it could be a lawyer, an advocate, pardon me.
A commissioner for oaths should be Article 149, under which the National Assembly has actually been able to dispense with by gathering and approving the nominee to the office of the Deputy President, has already passed. This particular name has been confirmed as Deputy President designate. This is a different scenario from the scenario where we have the President alongside the Deputy President who have won an election, like what transpired at Kasarani, where they all sworn in at the same time in the presence of Kenyans and by the Chief Justice. The provisions under this, under Article 149 going down, give a different scenario altogether. All right. And that is why you see the whole process, right from the time of the National Assembly to the time now of the Senate and the upholding of the impeachment resolution, of the impeachment resolution. This movement has been quite quick to the extent that a name is or has already been proposed and approved. And so its swearing in will not be waiting for this Chief Justice. All right. You will look at it and see. And I also have this official, notice and gazette. It's a special issue. And we're looking at this gazetted information published by the Authority of the Republic of Kenya. As we wrap up this conversation, the Gazette Notice number 13401, just coming in right now. And the National Assembly, vote by the National Assembly on the nomination of Professor Kithure Kindiki, EGH, to fill the vacancy in the office of the Deputy President
of the Republic of Kenya. It continues to say, it is notified that pursuant to Article 149(1), as read together with Article 122 of the Constitution of Kenya, the National Assembly has, at its sitting held on Friday, that is today, 18th October 2024, in the National Assembly chamber at the main Parliament buildings, voted in favor of the nomination of Kithure Kindiki, that is Professor Kithure Kindiki, EGH, to fill the vacancy in the office of the Deputy President of the Republic of Kenya. This Gazette notice is dated the 18th of October 2024, officially signed off by the Speaker of the National Assembly, Moses F.M. Wetangula. John Sakwa.
Yes, Swaka, just to clarify again.
Just in maybe 30 seconds as we
Yes. Yeah, I'm just looking at my notes, and under Article 149, there's an absence of a swearing provision. So you cannot insist that it has to be the Chief Justice.
Okay.
Yes.
Very interesting conversation there we have had with the legal voices. But John,
Yes.
first I want to appreciate you for joining us all the way.
Yes, thank you.
From early mornings
That's right.
until now. But these conversations might never end, as
Yes.
we are mandated by Kenyans to dig deeper into the constitution we promulgated as a country in 2010. You are very, very welcome for the
Thank you
next
so much.
conversations. That is
Yes.
John Swaka, who is a lawyer. I've also been engaging the advocate of the High Court of Kenya, Willis Otieno. Many thanks for joining us virtually. And Dr. Duncan Ojwang, who is also an advocate of the High Court. All of them bringing their legal interpretations of, number one, what has just happened, which is historic in the 13th Parliament. Remember, if this is complete and done and dusted with, Rigathi Gachagua becomes the first shortest serving Deputy President since the promulgation of the 2010 Constitution in the Republic of Kenya, just 2 years thereabout and a few days in service. But remember, the first Deputy President that served in this country under this Constitution is the now President, William Ruto. We continue to follow up on this, and a number of issues might arise in the corridors of justice. Do not forget, in hindsight, that the judges, and the last we saw was a 3-judge bench, declared that the courts are open to look at any other presentations by Rigathi Gachagua challenging, or, of course, in as far as the process is concerned, and now the impeachment conclusion by the Senate. This and much more, where you get the facts fast. And I will also bring into your consideration the National Assembly this afternoon voted in favor of the name presented to them by President William Ruto as the replacement of Rigathi Gachagua in this order. There was no one in absentia, the noes were none, and the ayes were 236. Well, Kalonzo Musyoka, the Wiper leader, and of course we have had also, together with the former governor of Kiambu, Ferdinand Waititu, and the DAP-K party leader, Eugene Wamalwa, saying that the Senate was was flawed, and that this particular impeachment has been criticized and condemned, and that Deputy President Rigathi Gachagua, former, will triumph. But that's it. We want to give way to business. We still need to know how the economy is working, regardless of what's happening politically. Thank you for joining me. My name is Anki Dorisumbat. Stay woke, stay patriotic.